Brought her, it doesn't fail the fact that he brought her to court in that vehicle, and he's using it outside his employment duties.
He doesn't.
I gave her a setting of when to come back, and she did not appear twice. I cannot have people who are not abiding by the rules of the court.
Welcome to the Court of Justice.
And NYMAC number 643337, State of Texas versus Patricia Pettis. All right, where we left off, the defendant informed the court that she and her husband emailed documents to pretrial services in regards to the totaling of her vehicle. So we've asked that pretrial services officer come to court, and she is here by Zoom. Any objection to the officer being here by Zoom, defense?
No, Your Honor.
State, any objections to the officer being by Zoom?
No, Judge.
But before we start,
Yes.
I just want you to know, I asked her husband to go home and get the proof that he emailed.
Okay.
So I don't know what she's going to say.
Well, we're going to find out.
Thank you.
Yes. All right. Ms. Macias, could you unmute for me, please?
Yes, Your Honor.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. If you could lower your hand for me and state your name for the record.
Officer Ana Macias from Pretrial Services.
All right. Brenda, are you able to hear?
Yes.
All right. We are here concerning Patricia Pettis. Have you been able to pull up the record on that case?
Yes, Your Honor.
All right. With regards to this, the defense's witness, Ms. Pettis, and also her husband have informed the court that they sent documentation by email stating that the car has been totaled. Do you have that?
Yes, Your Honor. On April 26th, 22nd, or 2022, Your Honor. I have the claim that I scanned it in, Your Honor, in regards to the 2006 Ford Mustang is total loss.
Okay.
Ms. Macias, what did you say the date was again? I think
I scanned it in her file on April 26th of 2022.
All right.
And I think in the pretrial violation, you submitted a pretrial violation to the court, a second pretrial violation regarding this issue earlier in April, correct?
Correct. I have it here on April 18th of 2022.
And in that violation, just for clarity of the record, there was a deadline that you had given Ms. Pettis earlier to provide you that documentation by a certain deadline, correct?
Correct.
And what was that deadline?
Give me a moment. Let me check. A deadline of April 16th.
Thank you. I'll pass the witness.
Any questions?
Did you get any emails before April 26th?
No, I have it here on my file that it was scanned on the 26th. That's the day I received it.
Did you talk to either Patricia Pettis or her husband, Mr. Brown, about the fact that the vehicle was totaled?
Let me see.
Before April 26th.
Before April 26th. Give me a moment. I'm checking my notes. I made contact on April 14th of 2022 with Ms. Perez, letting her know about the deadline of April 16th. She did tell me that the vehicle's totaled. I asked her for supporting documents.
Okay, so you were aware the vehicle was totaled. You just wanted paper.
Correct.
All right. Any other questions?
None from the state.
All right. Thank you for coming in.
Thank you. Am I excused, Your Honor?
Yes, you're excused.
Thank you. Have a great day.
Thank you, too. So here's the issue we have, Ms. Pettis. You were given deadlines, and you didn't meet those deadlines. That's why Judge Angelini doubled your bond, because you didn't meet the deadlines. You are on bond for driving while intoxicated, third or more. I'm not accept that as true, that it actually happened, because I haven't received any facts of that. But what I do know is that there are conditions of bond, and you need to follow those conditions. And I received, and could I see my documentation, please, counsel?
Yes.
Or-
Our documentation.
Yeah, thank you. Now, before Judge Angelini signed that motion, I received documentation that you were not calibrating. And what I did was I gave you 2 days to comply with calibration. And once that was done, I'm sure there was contact made with probation and with pretrial services. And just because you tell pretrial services your car has been totaled, they don't know if that's been totaled. They need documentation for that. So the question is, why did you wait so long? And you're still under oath. Why did you wait so long to provide them documentation when they told you that they needed that documentation April 15th?
I think
She gave her till 60.
her deadline was the 16th.
All right, April 16th.
I kept trying to email them, but I wasn't emailing them probably to the correct address or something, but I started emailing right away as soon as I got the paperwork from Smart Start and that. And
Did you pick up the phone and call them and said, I've been
Yes,
trying to
I did.
email you?
I did.
All right, State, what are you requesting?
Judge, I mean, I
And she
think,
does have medical issues. I don't know if you're aware of her medical issue.
I don't believe I am, Judge, but I think just from our perspective, I think that at the minimum, if the court decides to reinstate her bond, I think she just needs to be strongly admonished that it isn't so much, it sounds like she did tell them she was in a wreck, but like the court said, they don't have confirmation until they do. And I don't find it persuasive that she was trying to email their email. I think she just needs to understand that like she needs to communicate with her pretrial officer. And, if she's not able to do that, then obviously her bond could be revoked and she could spend her pretrial period waiting in custody if she's unable to comply with the rules that the court asked and the pretrial asked.
Do you understand that?
Yes, Your Honor.
All right. How did you make it to court today?
My
Her
husband.
husband.
Did he drive?
Oh, yeah, he was just here in the courtroom.
No. I'm asking her questions.
Oh, I'm
Ms. Carter.
sorry.
Yes, ma'am. He did.
Did he drive?
Yes.
Does that car have ignition interlock on it?
No.
That car needs ignition interlock on it. Do you understand?
It says, yes, ma'am.
Is it his work vehicle?
Yeah, it's his work vehicle.
Do you have a new car?
No, I don't. At the time, I
Do
don't.
you have a car?
No, I don't.
Can we put her on the PAN device?
Obviously, he's using his work vehicle, which we learned in law school, which is outside the duties of his work, but he's using his work vehicle to transfer her. Unless this is on a road, on a route to his job, no.
May I say something that
Yes.
I happen to know? He travels extensively. He and I have been in touch with each other.
But he brought her, it doesn't fail the fact that he brought her to court in that vehicle. And he's using it outside his employment duties.
He doesn't really live here much. He's on the road 1 week at a time. He and I coordinated when he could bring her here today because he needs to go back out. He has a company that he runs.
But she still has access to the vehicle. Is that vehicle in his name?
It's under his name. Yeah.
Yes. It needs to have
The only thing is she won't be driving it, just him. I just wonder, how do we do this if he's out of town, she's not driving, she's not in the vehicle, who's gonna blow?
no, it's going to be an ignition interlock on that device. And she's also going to be on another device for when she's at home, because I don't know if she's not driving that vehicle or not. It's in his name.
Okay, so he can blow in the vehicle when he's gone on a road trip.
He needs to let them know. I'm sure they'll be able to show that he's not in the county.
They have
But
video on
Yes.
those things.
so that vehicle is going to have ignition interlock on it, and you are going to be on a device as well. Do you understand?
You know, I don't think you know this. I'm court appointed. I don't think they can afford those two things at once.
Well, I mean, the only option she has is to be at the Bexar County Jail. Because I can't have her having access to a vehicle.
Yeah, he's
And-
never here.
How about we get a vehicle?
Okay, if she buys a vehicle, which she doesn't have, if she buys one, can the court order it to be on her vehicle so that he can go to work and be free?
No, because it's like every vehicle at the home has to have ignition interlock on it. I mean, that's just the way it is. All right. So what the court is going to order is the court is going to reinstate the bond of $10,000. There should be ignition interlock on any vehicle at the home and that defendant has access to. And we're going to do scram. And I'll ask that the fees be waived, deferred. on both devices, but I can tell you this, I don't have any authority to waive those fees because it's a separate a separate contract that the county has. But supposedly they have some sort of device out there that is free to people who are indigent.
Thank you.
You're welcome. If there's any more issues with you not reporting and not doing what needs to be done, we're going to have an issue. You're on 2022 CR 9288, State of Texas versus Patricia Pettis. Could I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Andrew Fraley, Ms. Perez.
All right. Have you had a chance to confer with the state?
Briefly, Your Honor, I was just retained this morning.
Mhm.
And after speaking with my client, finding out we retained knowing she had a warrant, there was a miscommunication about court on Friday. I would like to ask the court to reinstate the bond and provide some evidence
Okay.
as to my client's situation.
I will tell you this, there was no miscommunication. I gave her a setting of when to come back and she did not appear twice. So she's going to go into custody. They will, Ms. Ferguson will have a PR bond done for her. Once I review that PR bond, and since she's in custody, it should be fairly quickly when they get that done. I'll review the PR bond and you all can make your arguments, whether or not a bond should be reinstated or whether or not there should be a bond issued for her.
Sure.
All right.
Thank you.
So, Ms. Ferguson, on Patricia Pettis, we need a PR bond evaluation done. Yes, just the criminal history. And I do that because there have been changes, as you know, and that's the quickest way for me to get the case on docket if we do the PR bond. Otherwise, I can have it referred to Judge Carruthers.
Oh, no, Judge, the fastest way would be beneficial. We
All right.
appreciate that. If there's one thing I could
Yes.
approach the court on the record and introduce this email that I got, letting the court know, just first page is that she successfully completed residential treatment.
Mhm.
Second page is her discharge plan. The third page on here, Judge, lists her medical and mental conditions.
Mhm.
I just want to point out for the court, just so we have it on the record, medical issues, she has a colonoscopy bag, her psychiatric issues, bipolar, schizophrenia, and PTSD. And after speaking with her yesterday and today, I can assure you that the bipolar part is definitely going through a couple of swings. And the schizophrenia, Judge, she has made some numerous statements to me that would lead me to question whether or not she is mentally competent. So we will proceed with those. We'd ask the court in terms of any PR bonds. You wanted to wait for this, didn't you?
Oh, yes, because I don't have anything before me. And what I can tell defense counsel is that as a defense attorney and even as a prosecutor, I would take note of anyone who has any type of mental health issues. And I would always take that in consideration and try to get them help as quickly as possible. However, I cannot have people who are not abiding by the rules of the court. Number one, being reporting to court. Number two, having ignition interlock for DWI Third and all of the things that go along with being charged with the DWI Third. So we will come back on what date, Ms. Ferguson? Well, when do you think the PR bond evaluation will be done for her?
No, not for you.
All right. All right. So let's bring this back in 2 to 3 days.
Tomorrow, Judge?
Oh, that's not 3 days. All right. Let's give them a 2-week reset. But if it's ready before then, we'll have her here before then. No,
No bond set at this time.
no. I don't have any information to set bond. All right, Ms. Ferguson.
October 18th.
All right. So we're going to come back on October 18th at 9 a.m. and just check in with Ms. Ferguson in 2 days to see if it's available, because if it's available, we'll put it on the docket immediately.
I'll be here anytime the court needs me to be here.
All right, thank you. CR 9288, State of Texas versus Patricia Pettis. Can our parties announce for the record for the state,
Marcus Sanders.
for the defense?
Andrew Fraley.
And are you Ms. Pettis?
Yes, I am, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Pettis, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Ms. Pettis, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counselor, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. There's no application for deferred adjudication. State recommends community supervision, and there's $60 to DPS for testing. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State.
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, are there any such motions? Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a top evaluation, 100 hours of community service restitution, 10 days in the Bexar County Jail, MIC evaluation, DWI intervention, victim impact panel live, ignition interlock for half the term, or alternative for half the term, 2-year Texas driver's license suspension. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No conflict.
State any evidence.
Yes, State Office Exhibit 1 and its attachments.
Okay.
Ms. Pettis, I'm showing you what's entitled trial court certification. I'm sorry, waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Defense, do you have an exhibit to admit?
Yes, Judge. We asked you to admit defense exhibit 1 that is a written letter from her inpatient treatment provider. Since this offense occurred, Judge, she has successfully completed inpatient treatment for addiction. We would like to take into consideration.
Any objections to defense exhibit number 1?
No, Your Honor.
All right, counsel, can you tell the court how long was she an inpatient?
Approximately a month, Your Honor.
Okay. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. A couple things. In terms of what, at this time, Judge, my client lives, resides in Kendall County, Texas. We believe that might be the best place to reverse supervision.
Are you employed?
No, I'm not.
How you support yourself?
My husband has some business.
Do you have any children?
None, no,
Any grandchildren?
no.
All right, this is what the court is going to do. Court is going to sentence you to 2 years in prison, suspended and probated for 3 years, $60 to DPS for testing, 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Ignition interlock for half the term. We've been down this road before. Her husband has a vehicle. He doesn't have a vehicle. It works. It doesn't work. But she is going to have ignition interlock on any vehicles at that home. VIP live. There's to be a MIC evaluation that can be done out of custody. DWI intervention. Intensive outpatient treatment with probation. Sober meetings 1 time per week. There's to be a transfer to Kendall County. Proof of employment within 30 days. There's to be no employment as a home healthcare provider with minors. Regular reporting by Zoom or in person. And you can either do 10 days in the Bexar County Jail, or she will be on GPS for 30 days. And that's full GPS for 30 days. Which would you prefer? Yes. All right. So there's to be full GPS for 30 days in lieu of the 10 days at the Bexar County Jail. That will be 30 days from the completion of GPS. All right. Is there anything else that you need?
No.
Probation. Is there anything else she needs? All right. And we'll do the TAP evaluation out of custody. All right. Then add field visits 1 time per month random. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes,
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So you were driving intoxicated on Christmas. Sometimes when people are having their Christmas dinner, somebody always forgets something, like they forget the eggs to make the stuffing or whatever. That easily could have been a tragedy for some family. You understand? So obviously you can't stop drinking. So there's to be absolutely no driving, of course, while your license is suspended, because it's suspended for 2 years. And you need to make sure that you have that ignition interlock, and that's any vehicle at that home. You understand?
Yes, Mom.
All right. Is there anything else? All right. Is calling 2022 CR 4520, State of Texas versus Amanda Carol Griffin. Could I have parties announced for the record for the state?
Jason Garrett, hand, Your Honor.
And are you Miss Griffin?
Yes, ma'am.
Albert Gear for defendant, Ms.
Thank
Griffin, Your
you.
Honor.
Miss Griffin, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same? I'm sorry, could I have that last file back? Are you the same Amanda Carol Griffin who was placed on community supervision in 2022 CR 4520 for the offense of assault family household member previous conviction on September 18, 2023 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor, violated condition number 1, on or about the 9th day.
Everyone, please whisper.
On or about the 9th day of January 2025 in Bethel, Texas, the defendant Amanda Carol Griffin committed the offense of possession of controlled substance when they group 1 in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
Not away from violated.
Any objections?
No objections, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Is there a proposed agreement?
There is, Your Honor. It is to deny the motion and continue her on her probation. She is to go to plea on the theft case and the misdemeanor case to judgment sat, and then we will also take in consideration cause number 2025 PF 01181, which is the possession case she pled true to, and to alter and amend her condition to include UBRF.
Probation, is this your recommendation?
Yes.
Are you asking the court to follow this recommendation?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will find violation of condition number 1 true. The court will deny the motion, alter and amend conditions to include the following. Take in consideration I'm sorry, it was 2025,
Yes, Your Honor.
2025 PF 0181. Referral for DDRF probation. Is there anything else?
Want to make it clear that the other number one will need to be disposed or should be placed on it.
All right, so that needs to be disposed of as quickly as possible. Otherwise, you're going to be in limbo and they're not going to accept you.
Yes, Judge, I communicated that with County Court number 4 yesterday and told Seth that was set on the same day as today. So hopefully we can go right over there and take care of it.
Thank you. Good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
Patricia Pettis walked into Judge Stephanie Boyd's courtroom with a stack of excuses, but the judge wasn't buying a single one. First, she failed to provide documentation on time. Then, she showed up in her husband's work truck without the required ignition interlock. When Pettis pleaded poverty, Judge Boyd hit back hard: comply with GPS monitoring or spend 10 days in county jail. Days later, a gut-wrenching twist emerged. Pettis' attorney revealed she suffers from a colostomy bag, bipolar disorder, schizophrenia, and PTSD, and even raised questions about her mental competency. But Judge Boyd refused to bend. She sentenced Pettis to 2 years in prison, suspended for 3 years of strict probation, and demanded ignition interlocks on every vehicle at the home. This wasn't about cruelty, it was about accountability. The judge showed compassion by requesting fee waivers, but made one thing crystal clear: mental health struggles don't erase court rules. One more violation, and Pettis is going behind bars.